Today, Patrick, this is corporate reality check. We are talking about everything that happens in the corporate world, the knowns and the unknowns. There are those things that make people fall off, others thrive, others thrive, different things. So, and there are those other unwritten rules that happen in the corporate world. I am happy to have you today.
It's a pleasure to be
as
here.
a lawyer. You're going to tell us, Patrick, introduce yourself the best way you would want people to know you.
Okay, thank you, Sheila. My name is Patrick Mugalula. I am a lawyer, as introduced by Sheila. I practice with the firm of Katende and Sempebwa, a full-service law firm, and it follows that I'm a full-service lawyer. However, my specialty is employment law, amongst other things, and other legal needs that you might have. So it's a pleasure to be here. Perhaps as we go along, I shall give you more of a background and more insight into what we do, but I hope that gives you some picture of who I am.
So you do employment law.
Exactly.
But you also do other things. So we say in healthcare, there are specialties.
Yes.
Gynecologists,
yes.
there are cardiologists,
yes.
there are those ones, but they're all doctors.
True.
So for you are a lawyer, but you specialize in employment law.
Exactly.
Exactly. That's why I want you here. I want to have you here. So they say that lawyers lie a lot. How true is that?
It's not true. It's not true. It's just that in this modern age, you need to present the truth in a more acceptable way. So we present the truth in a more acceptable way. To be honest though, the majority of lawyers that I know are very honest people. That saying that lawyers lie a lot, it's not very true. I think it is one of those stereotypes that have developed over time, but we're very honest. In fact, if you lie and you're known to be a liar, your clients won't trust you, the court will not trust you. It ends up being a disadvantage on your side. So we're honest.
As a person.
Exactly. We're honest. And for those lawyers who are not honest, perhaps that's a personal failing on their part. Yeah.
Okay, you've defended the lawyers. Already you've defended the lawyers.
They say if you can't defend yourself and your people, how can you defend others? So
I agree with you. So Patrick, I have books in front of me.
Yes.
Dan Brown.
Yes.
It says Dan Brown, Angels and Demons. Have you read this book?
To be honest, I have not. I have watched the films, the very nice films, but I have not read
There is a
the
movie?
books. Yes.
Nice.
Yes.
Interesting.
Yes.
Okay. Maybe you can read this book.
Sure.
Then I have this book, The Bell is Ringing.
Yes.
Martin Alika's story.
Yes.
You've read this book?
100%.
Briefly.
100%. So briefly, it is the story of his life from the time that he was born during the colonial administration to a chief in northern Uganda, to his excelling in academia, going to the US, finding his wife, an American, coming back to Uganda.
He found the wife in America.
Exactly. He found an American while he was studying. They got married. They returned to Uganda and he set up a dental practice. Through that dental practice as a doctor, he was able to establish himself and he became a chairman of boards, a trusted advisor. He became one of the Africans who were nominating Ugandans to go and study on the British colonial bursaries in the US and in the UK. So he really, really established himself. And it's a good book that paints the picture of how Uganda moved from a colonial protectorate to an early young nation to the president that we actually have today. He tells all those stories of when he's in government, when he is in exile in Kenya. Really, really good book. And as a person who used to drink, he was once the board chairman of Uganda Breweries. And he
used to drink?
I used to.
You don't drink anymore?
I saw the light.
Hallelujah.
Hallelujah. Exactly. Yes.
So there is something here I'm saying, his student life. Nobody paid fees at Makerere.
True.
At the various governments took care of that. The government of Zanzibar went further, providing their students with a special diet.
True.
Mostly rice.
True.
Interesting. I should have lived
Exactly.
then,
Exactly.
so that I didn't have to pay fees.
Exactly.
Okay, getting back to our topic, we are talking about corporate reality checks. There is a time you contacted me and you had, I think, 300 people who are being dismissed. Was that called a restructuring?
Exactly. Yes.
And you needed an ambulance
Exactly.
to have. What was happening during that time?
Okay, so without disclosing the name of the
Not at all.
Yes, of the organization, this was an organization set up in Uganda. They had a complement of about 300 employees, and for one reason or the other, business had not gone as they expected. So they decided to temporarily, scale down operations, and that required our services as an employment expert to come and tell them that in order to let go of 300 people, there's a special procedure you have to follow in the law, and notices that you give them, you explain to them what's happening, and of course their legal entitlements, you give them to them, and you end the contracts at that point. Now, for us as an organization, it's not enough to say, have I met the law? I have to make sure that all the other things, psychosocial, mental support, everything that, if it was me going through this sudden end of my job, what would I want to see in place? So that's why we're reaching out for an ambulance. We organized the structured collective termination of those 300 employees. I can tell you that terminating one person 9 out of 10 times, you're going to end up with disputes. For those 300 people, we did it without a single dispute. Organization was closed well, and they're moving forward. I think I don't know how true it is, but I hear that there are plans to scale back up in the next, in the coming future. So, yeah.
So how possible is it that an employer decides to scale down 300 people at a go? Is this something that is questionable, their planning strategy? Because by the time you have more than 300 and you're taking away 300 people at a go, me personally, I would sue you for lack of strategy. You don't have a clear strategy. You've excited me. I left my job wherever I was to come to you for only for you to tell me, I don't know how long those guys had worked in that organization, that you cannot have me anymore.
True.
Is that a case?
I think, okay, so let me look at it 2 ways. The first thing is, I am biased. This was my client, so I have to see things from their side. The starting point is that this was really something beyond the client's control. The client, it was owned by a company which ultimately had control in the US, and there were certain financial
Was it
movements.
like a franchise or they are subcontractors?
Exactly. More or less that a company in the US invests in an African entity that is doing this kind of business across the continent. When they take a hit in the US, the question is, can we afford to keep putting money in this company?
I get it.
Yeah, without having a solid foundation that's coming forward. So when they found themselves in that situation, they asked us questions that, one, should we try and, what we do in Uganda, we just do things anyhow and see maybe the money will come.
Yeah.
Or two, should we be honest with these employees and tell them, you know what? Exactly. For now, what we can afford is this. Let us terminate. When things pick back up, we'll come back for you. We've kept your names. Even when we're ending right now, we're going to first try and get you jobs in the competitors. We'll reach out to the competitors and say, Sheila was an outstanding marketing officer. Please consider taking her for reasons X, Y, and Z. Now, if your competitor you've been fighting with tells you that, you take it with a certain level of authenticity. So to be fair, I think they tried to be honest. They didn't want to get a situation whereby people are left without a safety net, and that's why we did it like this. They paid over and above what people are entitled to show that we care, but this is what we can afford at the moment. But to your specific question, if an employer comes and they have no plan and they end up in this termination because they had no plan, and they get the procedure of terminating wrong, you definitely have a case. You have a case, and maybe as I conclude, the court that you're going to or the authorities that you're going to see it as their mission to protect employees who are being mistreated like that. So you come and they'll say that the law requires 1, 2, 3, 4. Was it done? Yes. The contract requires.
They have to tick.
Exactly. Yeah.
It brings me back to employees understanding their contracts. I get a job today. I rush to sign because I have an offer.
Yes.
What is the importance of employees getting jobs to thoroughly read and understand their contracts?
Yes. Now this one, let me steal the exam for you.
Yes.
Yeah. So the truth of the matter is, despite the fact that Lawyers, primarily, we are trying to represent the employer and protect the employer. The employment law in Uganda is structured in such a way as to protect the employee and ensure that the employee's rights, because going into this relationship, the law knows that the bargaining power is not equal, right? So the employer has money to dictate terms.
Usually the employer has a higher bargaining power.
Exactly.
Because me, I am desperate. I'm looking at this job. I want it.
Exactly.
Tell me.
Exactly. So the law comes in to protect the employee. The law is saying that if you have not been given a certain right, if the employer has not said, I'm giving you this right, the law is saying that in the absence of that specific provision, the law has guaranteed it for you, right? So all of that is to say that while you're going into this employment contract, looking to the contract that you've been given, really it's the safest thing that you can do. I think the best way I can explain this is there are two kinds of doctors in this world. There are doctors who will help you throughout the day-to-day to tell you that if you eat like this, you'll be well.
Like the wellness doctors?
Exactly.
Yes.
If you eat like this, you'll be well. If you do this, you'll not get maybe a heart condition. If you do this, you'll not get, doctors like that. Then the doctors who come
And
at the
treat.
very end. At the very end, and they'll tell you that because you've lived a certain lifestyle, you now have these conditions, and now we have to intervene.
That's what I'm talking. The wellness one and the one who will treat you.
Exactly. Exactly. So while you're going into the contract, you need to go to that first kind of doctor and say, what do I need to have in this contract?
The wellness one.
Exactly.
Yeah.
What do I need to have in the contract to have a long employment life, right? The doctor, who's now this employment lawyer, will tell you that, one, make sure that your pay has been clearly spelled out, and they've said that this is a net figure, right? You may negotiate very well, and you're negotiating a gross figure.
Yeah.
When the paycheck comes, the deducted pay, local service tax.
You negotiate for 10 million and aka 5 ma will drop in your account, and
There
you're
you
like,
go.
this is not what we discussed.
Exactly. But there's so many other specifics, right? Leave days. There are things like when your employment ends, there's something called severance allowance. If you don't put it in your contract, the law puts a default position which may be less favorable to you. So there are things like that which, unless you have the foresight to go into this contract thinking that, has my wellness doctor, the employment lawyer, guided
Thoroughly
me.
gone through this contract.
Exactly.
And we've had a conversation and I understand it.
Exactly. Maybe the last example I'll use is the parable of the house which was built on sand, the house which was built on a rock, the firm foundation. The contract is the foundation of your employment relationship. Before you even go to the law, what the law is saying, what is in your contract. Because there'll be so many things which are not. I'll give you another example. An employer has a right to put in a contract that your place of work will be, let's say, Zana, but I can transfer you to
Gulu.
Exactly, right? Now, if that is in the contract, and the contract is not saying that sending you to Gulu, you're entitled to additional allowance for relocation.
It's called out of upcountry allowance.
Exactly. Yeah. Exactly. So me as an employer can say, no, when we sign the document, we did not say that there'll be any allowance.
What was in the contract?
That is it. So this is your foundation. However excited you are, you pass the interview, you're the best, sit down with a lawyer, let them tell you this is what should be there, this is why this is wrong for you, negotiate with the employer. Most employers are reasonable. They negotiate, right? Negotiate with the employer and move forward. If it's an unreasonable employer, because being honest, right?
We have those.
Exactly.
Yeah.
If it's an unreasonable employer, still your lawyer can tell you that at least register your disagreement with this term. God forbid if the relationship goes sour, you've registered, you sent an email saying, this particular term, I'm not happy with it. They won't go to court and say, but we told you.
This was not discussed.
Exactly.
Okay.
Yeah.
What I'm getting from you is that there are two contracts.
Yes.
There is a labor law, and there is a employment contract. So you essentially saying that when I get my contract, I should look at it vis-a-vis what the labor law is saying for me to have a better conversation.
Yes.
Okay. So most times, again, when we get a job, we are very excited.
Yes.
You sign that contract, you get that money, you go away. But until that time, when things are falling apart, that you go back to the contract, they tell you, let's look at your, is it called placement contract, appointment letter, and you find details in that appointment letter are not things that you ever went through at all. at any point of your life. I'll give you an example. There is a time they called me for a disciplinary hearing.
Yes.
So in that disciplinary hearing, it was vague. There was no case. These things they put confidentiality, company, what, they're not very well defined.
Yes.
So at that time when they are calling me for a disciplinary, in my case,
Yes.
they told me I breached the confidentiality clause. When I went back, it was vague. But at least it was there for them. Me, I did not understand it. If a staff is an employee is going through such a situation, how would you advise them?
Okay, so the starting point, again, I'm going to beat a kalangu for myself.
Yes,
and
yes.
my fellow employment lawyers, please.
Yes.
The moment anything happens, the formation of a contract, a disciplinary notice, etc., find a lawyer, right?
Yeah.
And the reason is that there are certain things your employer cannot do, or even you as an employee, you cannot do without following process.
Yeah.
So if you get a certain letter, it may look harmless,
Yeah.
but there is a process which has been triggered. So find a lawyer, let them walk you through that journey. Now, there are two responses. The first thing is something you had mentioned, that in effect, there are two contracts. That's
Yeah.
true.
Yeah.
Right? Whenever you have an employment relationship, it's not just this contract which is in force. The first thing in force is the employment law,
Yeah.
which is in place. Whatever is in your contract, if it's different from the law prevails. The law is what applies, right? So for example, if we come and say that I will get 13 leave days in a year, the law is saying the minimum a person can get is 21, and you cannot agree to less than 21.
Yes.
You can agree to more, but not less. So that's all to say that your contract, your employment relationship is governed by, one, the law in place, two, the contract you've signed. Then there are other things which come in. So one of those other things is the human resource manual, the code of conduct, the disciplinary code, etc. And you must make sure you read all of those, because they're brought into the contract and become a part of the contract. So I bring all of that to say that, should you be ever called for a disciplinary hearing by your employer, one, look at the contract you read, whether you signed, look at your human resource manual, look at the code of discipline which is in that human resource manual. If the offense you're being called for either was not in place at the time that you allegedly breached confidentiality, or it is vague, it is something not clear, all of those are defenses. You remember,
you can argue them out.
Exactly. Remember, the disciplinary committee, they have a duty to be as fair as possible to you.
Which is not the case. I can openly say that with my chest out.
Unfortunately, right? Unfortunately. I think to be honest, the disciplinary committee is supposed to be as fair to you. And now again, I'll defend the employers a bit.
Yeah.
At the end of the day, the people implementing these laws are human beings.
Yeah.
So you can only be as
So they
good
have
as
biases.
Flaws, some things are just, even the employer doesn't know, some things are mistakes, they made a mistake. All of those factors come into play. For you as the employer, and rather as the employee, any mistake, any bias, any gap works in your favor. You can simply go to court and say, we didn't do this.
There was a gap here.
Exactly.
For my particular case, if I may, I called the lawyer because they gave me that invitation to disciplinary hearing. I shared it with my lawyer. I had to bring out my employment contract. They looked at it and they're like, A, B, C, D. Like there was a whole correspondence between me and my lawyer. Yes. I told my employer, can I have my lawyer in for this hearing? And they said, no, you cannot have your lawyer.
Yes.
But then the lawyer guided me on how to manage that. When I went for that hearing, I remember asking them, I requested them to record the session. They were a bit hesitant, and then they said, okay, it's okay, you can record the session. True. The session was recorded, and I don't know whether other disciplinary hearings happen like that, but my hearing was less than 20 minutes. Okay. And you've talked about biases. One of the people who are seated in that disciplinary said, if you didn't have these correspondences, I don't know what this hearing would turn into. True. Which means already you're taking me for a disciplinary hearing, but you're already biased. You already have a position. True. So that's where now law comes in, lawyers come in. Exactly. I'll ask a question. Yes. For people, middle managers, aspiring managers, and exco and who, would you advise that every person has a personal lawyer the same way we have personal doctors?
Absolutely. Absolutely, and this is why.
Yeah.
The starting point that you mentioned, you went for a disciplinary hearing and they said that this is internal, you should not come with a lawyer.
Yeah.
That's already wrong. The law makes it express that whenever you're called for a disciplinary hearing, you have a right to attend with a person of your choice.
Yeah.
Right? So it can be your lawyer, it can be a friend, a person of your choice. That's what the law says. So if anyone ever tells you that lawyers are not allowed here, document it. Just send an email and say, can my lawyer come? Then the response will come, no. That's a breach of process already, right? Then the second thing is on bias that you've mentioned. In order to make sure that this process is as fair as possible,
to both parties.
Exactly. The court looks out for two things. One, have you followed procedure? And I'm going to unpack what procedure means. Then two, were there reasons for the dismissal? Now, in your case, you've said the allegation is breach of confidentiality. The question the court is asking is, but in reality, did this person actually breach the confidentiality? Or is this something that perhaps the new boss doesn't like the person and they're finding an excuse? So they will look at that substance, but that comes after they look at procedure. Now, in procedure, there are so many things, and this is where most employers get it wrong. This is really, 5 out of 10 of my day advising on procedure. The first thing of procedure is there must be a neutral decision maker who is not biased. You understand?
And is that a lawyer or it can be someone internal?
Anyone.
Anyone.
Usually internal, because now, truthfully, lawyers, we may prolong something which would have been.
Okay.
Yeah. So usually someone internal who knows how the
Sometimes
business
you
works.
can also side with who pays you.
Well, on that one, I will not comment. But yeah,
Okay.
so have a neutral decision maker. Let the neutral decision maker not be biased.
Yeah.
And bias, unfortunately, the law places a very high standard. Bias can be actual bias, like you rightly said. That
Yeah. If you didn't have the correspondences, I don't know what this would turn into.
that is actual bias. That's someone saying that they are looking towards a clear outcome, and it really shows they've already made up their mind.
Yeah,
They have
yeah,
a position
yeah.
already in their mind. That's actual bias. But there are also cases of what we call either implied bias or ostensible bias, or I've forgotten, there's another third word, but what it means is that if
Is that unconscious?
more or less
More
unconscious,
unconscious, okay.
what you're looking at is that if an objective third party came and looked at this picture, would they think that the decision maker is objective?
Yeah.
As an example, if I'm appearing before, I don't know, a sibling of mine,
Okay.
right?
Yes.
I'm the one accusing, and the decision maker is my sibling, the employee is on the other side. What are the odds that my sibling will decide against what I'm saying? You understand? They won't. Right? And even if they could, it doesn't look like,
Even if they were right, it would
Yes.
not seem like they are actually
Exactly.
right.
Because of that possibility.
Yes.
There's that saying we have as lawyers that it's not enough for justice to be done, it has to also be seen to be done. The process has to be seen to be fair. Right? So procedure, you're looking at that neutral decision maker, then you're looking at all these steps that the law requires. Notify Sheila in advance, give her 5 days to prepare,
Yeah.
give her all the evidence in advance. She has a right to bring her witnesses. She has a right to cross-examine my witnesses who I bring against her. All of those checks must be in place. Yeah.
Ah,
Yeah.
interesting. So it takes me to dismissal. Now we are out of the contract and so on.
Yes.
At what point is dismissal fair?
Okay. So the moment you hear dismissal, there's so many things to unpack. And really, the next time your lawyer charges you, please understand, these things are really, please understand. Yeah? So the moment you mention dismissal, there's so many things which come up. In employment, a contract can end one of two main ways. I can terminate you, or I can dismiss you. So if I dismiss you,
I am interested in understanding both.
Exactly. So if I dismiss you, I'm saying that I am ending the contract because of something you have done. You are at fault.
There is something I did,
Yes.
touched company money,
Exactly.
assault,
Exactly.
those things, so I am dismissing you.
Yes. In fact, the categories are two. Either you've done misconduct,
Yes.
yes, or you've done poor performance.
Oh, poor
Yes.
performance.
Yes,
It
that's
results
this.
to dismissal.
Exactly.
Okay.
Right? So
Fairly appraised.
exactly.
Okay.
Exactly. So dismissal is where it relates to the conduct and the fault of the employee.
So the conduct takes us back to HR manual. That's where
Exactly.
they stipulate the codes of conduct.
Exactly.
Okay.
Exactly.
Cool.
So then the other hand is termination, where I'm saying that the contract must end, but it's not your fault, right? One example is you've reached retirement age. You're the perfect employee. There's nothing wrong you've done, but retirement age has been reached. Or another example is the one we talked about, right? The business has run out of money,
Yes,
right?
yes, yes.
So it is not your fault. You're exemplary as an employee, but we simply don't have the money to continue in business. We terminate. So yeah, coming back to your question, dismissal, what it means. There are those two routes that were mentioned, either performance or misconduct. It can be an ordinary dismissal, whereby I've done something serious and it's wrong, and you need to chase me, but it's not as bad as it could be. Then there can be something called summary dismissal.
Summary dismissal. You explain that, then you explain an appeal.
Okay, fantastic. Okay. So summary dismissal means that the thing that I've done is so bad that it goes to the heart of the contract that we have. An example is if you hire me as a finance person and I steal money, right? It goes to what the law calls a fundamental breach of your contract.
Of
You've
your
gone to the
contract,
heart
yes.
of the contract
Yes.
and broken the contract fundamentally, right? Then on the other hand, ordinary dismissal is perhaps I've been coming late, Monday, Tuesday, Wednesday, Thursday.
Yeah.
You warn me, I do it again, right? It's serious, but not as serious as that. Now, the funny thing is that the only real difference between dismissal and summary dismissal is that once the disciplinary process has ended, in dismissal, you give me a letter saying that here is your notice payment, here is the things you've earned, please buy, move on, right? For summary dismissal, there's no notice, right? I just say that
Tomorrow don't appear. Bring back the company property.
That is it.
And go.
Please buy.
Oh.
I just write the letter.
Okay.
But I still have to follow the procedure.
Yeah.
You come for a hearing, etc. Yeah. So once a disciplinary committee has sat down, they've had your evidence, you've brought your witnesses, you've checked their witnesses.
Yeah.
After all that process, and the committee has said, Sheila, I'm sorry, your evidence is not sufficient. We're still dismissing you.
Okay.
They usually give you a right to
appeal
it to someone else. And that appeal, you're saying that the disciplinary committee made a mistake. You understand?
Whom do you appeal to in this case?
Now, that's what I was. That's the unique thing about appeals. Most of these employment procedures are set out in the law, and their rights guaranteed in the law.
Yeah.
If you don't get a disciplinary hearing, that is a breach of the law. But appeals are unique. Appeals are usually internal by the organization. They're not. There's nothing in the law that gives you a right to an appeal, right? So if I don't give
There
it
is
to you,
nothing that gives me a right to an appeal.
in the law, yes.
Oh.
So if I don't give you that appeal in the human resource manual, you cannot
It
base
is
on
okay.
that. Exactly.
You cannot say that I've been denied an appeal.
Exactly.
Ah, okay.
But if I do put it there in my manual, I am bound by those terms and I must follow through. So usually the appeal goes to the most senior person in the business. You're saying that?
Maybe the CEO.
Exactly.
Okay.
Exactly. And the CEO, basically you're telling the CEO that I am unhappy with the decision that the disciplinary committee has reached. And the reasons are, one, maybe there was bias. Two, they didn't consider this evidence.
Yeah.
Things like that. And usually, my experience is that they'll uphold the decision.
Yeah.
Because it's not supposed to be this way, but most times that decision is being made by management to dismiss.
Yeah,
So
yeah.
the CEO somehow is aware. It's not supposed to be that way, but usually they uphold. The cases where they intervene and set aside are where there's something really glaring. Anyone can see
So they
it.
can tell them, kindly review.
Exactly.
Review this disciplinary summary findings.
Exactly.
Okay.
Yes.
Okay. So there is something also called, I think it's called mutual separation.
Yes.
How does that sit in?
So think of mutual separation like the law is saying that you agreed to come and work together. You can agree to end the employment relationship. That is it. So usually when you are a very senior employee, even the employer feels that subjecting you to a disciplinary may be, because
Also
of your
damage, your
seniority.
personal brand damage. Yes,
Exactly.
also the risk of getting another, I know words travel very fast.
Exactly.
Getting to another employment may be a bit hard.
Exactly.
Okay.
Yeah, so usually what they do is they come and they sit down, we have a very amicable discussion, and we say that, Patrick, you've been an exemplary employee. However, for reasons X, Y, and Z, we feel that perhaps we should go our separate ways.
Mutually.
Exactly. Now, the power in mutual separations, unfortunately, fortunately, is with the employee. Because it's a contract and you must agree. You say, I will only sign if you pay me X. Right?
So the employee in this case has the upper hand
Exactly.
to
They
negotiate
must agree.
this
Yes.
mutual separation.
Yes,
Okay.
whereas in all the other modes of separation, the employer can do it on their own. They just wake up and call you for disciplinary, right? There, of course, there are rules about when you can call it etc., but it can be by the employer without the employee's agreement, right? So there is a bit more power on the employer's side. They drive that process. Yeah.
So there is something interesting about what was I going to say? It's skipping my mind. No, organizations.
Yes.
Is there anything called legal awareness? Should employers have that thing called legal awareness, or they cannot dare go there because when they do that, they are going to empower their employees to seek out for legal advice every now and then? Is it something that you've ever done before?
Yes. It's something that we do. We do it often.
You do?
Yes.
Oh.
So a number of employers call us and they say, do a training for
Yes.
employees.
Apart from proud privacy policy,
Yes.
just legal awareness. What are my rights? What are my responsibilities in this organization?
Yes.
That's something that you do.
Absolutely.
I am very interested.
Absolutely. Now, the way that I look at it is this.
Yes.
You can say as an employer that if I train my staff, they're going to be aware of their rights, and that could increase their lawsuits. But if you don't train them, you're opening yourself up to more liability, because you have people who, let's say, managers who don't know what disciplining should
Means,
look like.
yes.
Exactly.
Yeah.
So I think it is more dangerous as an employer not to equip your staff with all the skills that they need.
Especially if you have a number of managers.
Yes. Yeah. The more that you don't equip them, the bigger risk you have. There's that saying in the corporate space that, what if we train our staff and they leave?
Yeah.
And then someone says, what if we train them and they don't leave?
Yes,
What
that
if we don't train
is
them?
usually finance. What if we train them and they leave?
Yes.
And the other one is, what if we don't train them and they
don't
stay?
leave. Exactly.
And they give you bogus work.
Exactly.
So tell me about that.
Exactly. So our approach is, you train them as much as possible. We find a way to tailor the training to the crowd that's going to receive it. So that, if you're a staff member, you know your rights. You have a basic sense of your rights. There are things like, of late, sexual harassment. We do sexual harassment training. There are things like that whereby a person will say that, no, I was just flirting with person X. We're just friends. This is friendly banter.
But what if I'm flirting with you and we are mutually flirting, and because things have not gone as good, you said that I was harassing you?
Yes. Now, the training that we give will show you where the boundary is. If it is a mutual thing, there are recommendations that we make. Go and declare to HR and say that, Sheila and
who does that?
You know, it protects both of you.
Yes.
Exactly. It protects both of you that Sheila and I, we have a relationship. Of course, also HR should not be very intrusive. That, where have you
so how far?
But at least let it be disclosed to the business, so that you're protected as Sheila and protected as Patrick. Neither of us is going to make an allegation that I was forced into this relationship in exchange for
whatever it is.
etc. And you have a basic sense of what the law says is sexual harassment. There are people who say that you send something funny on the group office WhatsApp chat, and that's harassment actually in the law, right? But people don't know that, and I know people do that in a number of workplaces.
So like a message like what?
So for example, if I find a message of a hot chick, a very beautiful chick, wearing, something very skimpy, I put it in the group, and I say something, something suggestive that is, oh no,
Someone one time told me, actually, I hate this guy with passion. I passed. I found a group of boys. They were in a room, and there is something I wanted from one of them. So when I asked, let me say, Patrick, the ABCD, as I was leaving, one of them said, "Akonkalia." Yes.
Harassment. One time.
I hated that, and this guy was in HR. I think I still hate him up to now. I hate him with every fiber of my being.
No.
Every fiber of my being.
Now you find that someone who's saying Akonkalia, of course, some of these things, it's, the society that we've grown up in, it's friendly banter outside work, etc.
Yeah.
But to you as Sheila, who's experiencing this in the workplace, it is, the law says, reducing your satisfaction in the workplace, right? You're saying, this is the person I supervise. I'm supposed to hold them accountable. They're making these statements. They're making them to juniors. You understand?
Yeah.
That reduces your ability, enjoyment of work, your ability to be in a safe working environment. All of that is actionable. And for employers, why this is very important is, if you declare that to HR and they do nothing, you have a right to escalate.
Yeah.
And the employer will be liable to you. The person will also be liable to you. Right? You can go to the labor office.
This is good information. Yeah. If you have people telling you a concalia and they're telling you how your bum is nicely shaped lately, that is harassment, and you can report your HR.
If it's in the workplace?
Yes,
absolutely.
Workplace.
Yes.
Oh, yeah. Okay. So now going back to something that is different. I have been given a promotion.
Yes.
Not me. Stating.
Yes.
I've been given a promotion, okay, verbally being promoted, and I don't have a letter that shows that promotion or the benefits that come with the promotion. How that 1, 2, 3 months, how do I go about that as an employee?
Okay. So
without seemingly, without making it seem like the employer is doing me a favor to have this promotion, because that is also the notion that I'm promoting Patrick, but I'm doing Patrick a favor to have this promotion. Yeah.
So you find that, again, I think it is a social thing. Our society is we're very polite. We're very, you look at the employer kind of the same way that you look at a parent. Let me not put pressure.
That is true.
Yeah, there's that cultural overlay which impacts in the workplace. However, what the law is saying, and what ideally should be the case is, despite the fact that you're my employer and I'm answerable to you, this is a contractual workplace relationship. You have duties, I have duties, right? You hold me accountable for the duties that I've signed up to. You must equally be accountable for what you've signed up to.
You've given me additional roles. I am working, but there is no any compensation or anything written in that regard.
Fantastic.
Yes.
The advice I would give you as an employee is, you write to your employer, right? It can be an email, it can be formally, and just say that, thank you so much for the discussion we had on date X, Y, and Z, where I was informed that my new role is this, and that.
Or my additional roles are ABCD.
Exactly. And then you say very politely that, given that these are additional roles, more than what I initially signed up to in my contract, I request for a new job description which clearly lays out these roles, but also confirmation of the additional commensurate salary for the increment. At the end of the day, if you don't document it, it can be presumed it didn't happen. So document it as much as possible. Be polite, but be assertive with the employer.
Yeah.
And what I was going to say is that the law requires the employer to have documentation for all these things. Your contract should be in writing.
Yeah.
The rules of the workplace, the manual should be in writing. They should be in a place where they're available to you. What most employers don't know is you're entitled to a pay slip at the end of every month, which shows this is what you've voted. So all of these things are actually your rights. And whatever is your right is a duty on the other side. So they have a duty to give you those documents. If they don't give them to you, your first port of call, before you go to the labor office, come to a lawyer, right? Let the lawyer write for you, right? And perhaps for employers to get a sense.
Lawyers are getting business now. If you're out there and you don't have a lawyer, look for a lawyer.
Absolutely. Yes. I think it's important for you to have a lawyer, because if you don't know your rights, you can't assert them.
Yes,
your lawyer who knows your rights can assert them on your behalf.
Ignorance is bliss, they say.
Exactly. But you'll be there in bliss, your rights are passing you by.
So I want to ask on the same, what happens to the relationship? Also, again, we are human. I write to my employer, HR, or whoever, the following this conversation that we had, ABCD,
Yes.
you come off as if you're passive aggressive.
I hear you.
Yes, the relationship, the image that you will be tagged around you is going to be different.
I hear you.
How do you manage that? Now, getting away from the low bits, how do you manage that as a human?
I hear you.
Because now every time you write like this Patrick,
It's a difficult
or gets
employee.
difficult employee. In fact, they are tagged difficult employees.
Okay, so I think...
And for most organizations, they want as much as possible for you to get out.
True.
Yeah, because now you're
difficult.
Yes, you're difficult.
True. Okay, so this is, at the end of the day, now this one ultimately comes down to the human-to-human relations.
Yeah.
You're going to have to find a way, unfortunately, of maintaining a good working relationship, at least with HR. And the reason for this is HR is the first point of contact, and they must know these things. For example, either they're aware or they have a Patrick on the other side advising them that Sheila is entitled to this contract. You must give it to her. So perhaps practically, like you've said, my advice would be sit down with the HR person on the side.
You first have that conversation before the email goes up.
Exactly.
Oh, okay.
One-to-one, and you say, man, I need this contract. I just need to know where I stand, just for my records, etc. And get a sense of where their mind is at as HR.
Yeah.
The response that they give you will let you know what you need to do. But at the end of the day, you'd rather be a difficult employee, I'm telling you, right, than a meek employee who, you're meek, you're pressed down, and eventually when a decision to terminate comes, you will not be
have no
saved.
defense.
Exactly. There's a saying that your meekness will not save you. You understand? So assert your rights. You understand?
Yeah.
And by the time the organization is promoting you, it is a recognition of your value to the organization.
Sometimes.
Okay, well, fair enough. So I would think, take the risk, assert yourself, but assert yourself respectfully.
Yes.
And always have the one-to-one
I think
chat.
the bottom line, assert yourself respectfully.
Yes. Always have the one-to-one chat, but then eventually follow up. Maybe the last thing
after the conversation, you advise that I have a lawyer friend.
Yes.
She does not do anything, not in writing. You'll have a conversation, and the next minute, dear Sheila,
Exactly.
Like, what is the importance of having records?
Yes. That's what I'm saying, that eventually when you end up in court or any legal forum, if it is not written, it didn't happen. So you make sure that you document it. It is email, it is in writing. If it is in writing, there is a stamp, it was received.
Yeah.
Because if it is not written, it did not happen. The other thing I wanted to say is that now for the organizations, the employers, if you leave a person in acting capacity for too long, that can be deemed to be a constructive dismissal. You've actually chased the person. Yeah. So you need to be very clear. Also, if you change a person's terms of employment to their disadvantage without their consent, that's a constructive dismissal.
Okay.
I'm telling you. So the rules...
If they change your roles without your consent, that is called constructive dismissal. So you can consult a lawyer.
Yes. In fact, what I'll tell you is anything unlawful or anything which no reasonable employee would accept and continue serving, if an employer does it, that's a constructive dismissal. I'll give you an example. If you come to work and they've taken away your desk with no explanation, nothing, where you're supposed to sit, the things you used to work, they've all taken them away. And there's no explanation, right? Despite the fact that you can go home and work from your home computer, the fact that they've taken away the office tools is a constructive dismissal. Another example.
I am glad that I'm hearing this.
Yeah.
So if I go and I find my fan has been picked from my office,
no. It has to be
a tool of work.
Exactly.
It has to be a tool of work.
Exactly.
Okay.
Exactly.
I was going to go and look for my fan. I'm like, hey, you guys took my fan from my office. This is a constructive dismissal.
There you go. You've been in office. You know.
Yes.
But
I think that applies because I can't be in office and I'm sweating. I don't have a fan. That is constructive dismissal.
I think.
Or that is entitlement.
I think I would agree with you, but I don't know if the court would agree with us. I think it has to be something.
A tool of work.
Fantastic. That's it.
Okay.
Yeah. But another example which most employers overlook is leave, right?
Yes.
If I apply to take my leave in this year, right? I say my 21 days are up. December is coming up. I want to take the 21 days.
Yeah.
And the boss says, no, December is our busy season. Take
Yeah.
it next year. In the first year, it's allowed. In the second year, you don't even need to ask. You tell your employer, I'm going on leave for last year.
But I also, that comes back to a conversation that you're having with your employer.
Now for
because
that,
surely it
yes.
could be a busy season.
True.
And you have the whole year to take your leave. You don't
True.
take it. You know, there are also staff that never want to take their leave.
I agree.
I think that should also be investigated, because how
Yes.
can you work the whole year and you're not taking leave? At what point do you rest? What is it that you're keeping at work
I agree.
that when you go, it will not happen?
True.
But I hear you.
Yes.
2 years, my leave has been denied.
Yes.
Yes, I can.
Yes. In the second year, let's say 2025 leave, you didn't take it, they told you were busy. Whenever you applied, were busy. It carries over to 2026. In 2026, you don't ask. You inform your employer, I am going on leave. And if they refuse, that's a constructive dismissal, right? So there are interesting scenarios like that we've seen.
It's not that I don't take leave. I take leave as and when I want to take leave. But I've also seen people who never take leave at all.
Yes.
I don't know, because they've been denied or because they don't want to take leave. But now we are getting it. If you don't take leave first year, second year, and you've been denied that leave, that is constructive dismissal, you said.
Exactly. But it needs to be important that you've carried it over to the second year,
Yeah.
and in the second year, again, you're being denied. What the court is trying to achieve is the employer should not use that trick of push it to next year to effectively deny you your leave. Because like you said, this is a health thing. It's a health consideration.
What if I ask for my leave to be paid?
So if that is provided for in your human resource manual, it is okay. It can be permitted. But the policy at the court and in the law is to discourage that, because the assumption is that as a human being, you need rest. You're not going to work.
We do. That is true.
Exactly. 365, you break down.
Yeah.
Yeah. So if it is allowed in the workplace, you can have the discussion and they encash the leave. But I would advise against it. Yeah.
So why we're having this discussion is because a lot of things happen in the corporate world. From when you enter that employment, how you're received, how you work every single day, the things that fall apart because you did not read your employment contract very well. Now, Patrick has told us you have to also refer to the labor law. See, what is the labor law saying? We are very desperate to take the jobs, and it's not bad because also jobs are scarce. When you get this job, you want to just grab it and start working. But be careful, read that contract, compare with the labor law, know exactly your rights, your responsibilities when you're serving that organization. I don't know whether the bit of salary is something that lawyers have to understand. I don't get the point that I work in this organization for 1, 2, 3 years and my salary is not increasing, and it's increasing. If it increases, it's a peanut like this.
Yes.
Is that something for the lawyers or for the HRs to discuss?
That's for HR and the business.
Yes.
What I can say from a salary perspective, one, just make sure you negotiate with the net figure in mind, do the computation.
That it goes back now to the negotiation when you are having that
Yes.
conversation before accepting. Because the organization can also tell you, we do not increase salary until 5 years.
Yes.
So depending on the conversation you had when you are coming in.
Yes.
Okay.
The law also provides protection for equal pay, right, to avoid discrimination. But now between you and
What
me,
is equal pay?
Fantastic. That's a good point. The employment law requires that there is equal pay for equal work. If we're at the same level doing the same job, unless there's a demonstrable reason why Patrick should get more than Sheila. Unless you have that clear reason that's objective, we should be getting the same money.
What if my negotiation was different from Patrick's?
Now, those are the questions, right? So the law provides for equal pay for equal work. But the question becomes, one, if Sheila's negotiated better, if, for example, there is more demand for you, right? There are two employers, and we need to convince you to come here, right? Is that fair to insist that we increase Patrick to match you? No, I don't think so. You may even insist and say, I am more valuable in the market, pay me more, right? So maybe the other thing is that I don't know what you mean equal work, because the way people do the job is not the
It's
same.
different.
Exactly.
My competencies are different. How I show up is
Exactly.
different.
Exactly.
My aura. You know, I'm supposed to be paid for the
Yes.
aura that I bring at the workplace.
Yes.
My aura is different.
Yes.
So you cannot be paying me
Yes.
the same as this
Yes.
gloomy person who delivers,
Yes.
but their aura does not.
I hear you. Yes. Yes.
You need to be paid for your
No,
aura.
yeah, true. These are the intangibles. Yeah. No, I agree.
Yes.
So it's one of those things we have in the law. Even the courts have acknowledged that there must be equal pay for equal work. But the question is what is equal work? And are the people who are doing this equal work valued the same by the business for whatever reason, like you said?
Yeah.
That aura thing that you've mentioned is a very big factor, because if we need to promote Sheila, if we need to make you a director, etc., we need someone who will represent our brand.
Yes.
You understand? So
Said that again.
so there you go. Yes. So the aura of someone who represents the brand, and the organization knows that we've sent Sheila here. Yes, that is it. We'll put our best foot forward.
Yeah.
Right. So it's one of those impractical things that's in the law. We've only seen one case where it went before the court, and they laid out all these principles, but eventually they ran into this roadblock. And I said, but
should we think that it's still subjective?
Yes.
It works on case-by-case basis.
Exactly.
Oh, cool.
Exactly. Because there'll definitely be cases where you have 3 legal officers, they're doing identical work, they have the same qualification. Now it's a very clear-cut thing. There's no basis to pay one more than the other.
Yeah.
Yeah. But in certain cases, in most cases, it's very difficult to equate. Yeah.
So after having this conversation, when I see that gentleman there, you just know that our time is up.
Yes.
We have only 45 minutes to have this conversation.
Sure.
I want you to give our listeners your last shot. What would you tell them as Patrick, the lawyer, that does not lie, that represents employment specialist in this case?
Yes.
Tell us, what would be your last shot to the employees? Leave the employers now.
Enough.
Yes,
Fair
employees.
Enough. Okay, firstly, thank you so much for listening in. I would think that employment is like your health. For most of us, this is where you get your sustenance and livelihood.
Yeah.
Plan for it the same way you plan for your health. Have a lawyer to help you, guide you through these processes. Don't take it for granted that this is just work.
Yeah.
It's something that I can do. At the formation of the contract, at the end of the contract, most importantly, in the middle, while you're doing the job, consult your lawyer. Approach this thing like an equal party. Don't bring in that aspect of, be respectful, yes, but don't bring in that aspect of, this is my employer, let me be meek, let me not ruffle feathers. Because, God forbid, at the end of the day, when the shit hits the fan,
false humility.
Exactly, yes. The employer will survey all their options and take the decision which is best for the employer. So also you do the same, right? That entails planning, having a focused plan going into the employment, being respectful at work, doing your job, speaking to a lawyer, read the terms of your contract well, where there are changes to the human resource manual, talk to a lawyer again, right? And know them by heart. Yeah, and at the end of the day, please reach out to me. I'm here to guide you. This is what I'm here for. Yeah, and if there's anything else, please don't. I feel like there's a bulk of authorities, a plethora of cases. There's so much writing online about all these things which we think are the tricky areas in the employment relationship. Yeah, at the end of the day, that's it. Please don't fear us. We're here to support you. Reach out. Yeah.
Thank you so much, Patrick, and
welcome,
thank you for sparing the time. What I've picked from Patrick today, he's a lawyer. So he said, don't fear us.
Yes.
Most people fear lawyers, and for some obvious reasons, some because they think lawyers are very complicated. But why we're having this conversation today, again, is because very many things happen in the workplace. Workplaces have different things. People go through different things, but they don't know how to address them. So we particularly said, let's have a conversation with an employment specialist who is a lawyer to tell us the things we need to know, the things that our employers also know, and we take advantage of those so that we enjoy our employment. Thank you again, Patrick Mugalula.
Thank you so much. Okay.
Do this. You can't be a serious lawyer. We are done. You can now greet me.
There you go. I was wondering. I thought. Thank you.